I would like to speak on two proposals. The proposal for a Council regulation in matters of matrimonial property regimes, and the proposal for a Council regulation regarding the property consequences of registered partnerships. The negotiations in the Council have in particular highlighted the two following elements. First, both regulations leave untouched the underlying institution of marriages and partnerships, which should remain a matter defined by the national laws of the Member States. In particular, nothing should oblige the Member States whose law does not know the institution of registered partnership to provide for it in its national law. Secondly, particular attention has been given to ensuring that both regulations would contain, as far as possible, parallel provisions. And the discrepancy between the two regulations only exists when the significant differences existing between the institutions of marriage and registered partnership justify it. Both texts have reached a high degree of maturity. A possible compromise text has been submitted in December 2014 on the two regulations to the Council. Now, I would like to concentrate my attention first on the proposal on matrimonial property regimes, and then we'll go in a second moment to the registered partnerships. Regarding the matrimonial property regimes, there are four aspects that I would like to focus: scope, jurisdiction, applicable law, and finally, the recognition and enforcement. Let's start with scope. And here we have to say a word about the territorial scope. The regulation should be applicable the day that it will be adopted by 25 member states. In fact, UK and Ireland were decided not to make the opt-in, and the regulation will not be applicable to Denmark. On the material scope, the scope of the regulation should include all civil law aspects of matrimonial property regimes, both the daily management of matrimonial property and the liquidation of the regime, in particular as a result of the couple's separation or the death of one of the spouses. On jurisdiction, I would like to mention four aspects. In fact, the regulation should enable the citizens to have the various related procedures handled by the courts of the same member state. To that end, the regulation should seek to concentrate jurisdiction on matrimonial property regime in the member state whose courts are called upon to handle the succession of a spouse or the divorce, legal separation, or marriage annulment. In order to increase legal certainty, predictability, and the autonomy of the parties, the regulation should enable, under certain circumstances defined in the text, the parties to conclude a choice of court agreement in favor of the courts of the member state of the applicable law. Exceptionally, the courts of a member state whose private international law does not recognize the marriage in question, for the purposes of matrimonial property regime proceedings, should be allowed to decline jurisdiction. This means that the regulation just creates conditions to enable the parties to have alternatives when the court of a member state declines jurisdiction. Now, the last aspect is that the regulation should provide for a scale of connecting factors for the purposes of determining jurisdiction, starting with the habitual residence of the spouses at the time the court is seized. These factors are set in view of the increasing mobility of citizens and in order to ensure that a genuine connecting factor exists between the spouses and the member state in which jurisdiction is exercised. Now, the third aspect on the proposed regulation on matrimonial matters is the issue of applicable law. The regulation should enable the spouses to know in advance which law will apply to their matrimonial property regime. The main rule should ensure that the matrimonial property regime is governed by a predictable law with which it is closely connected. For reasons of legal certainty, and in order to avoid the fragmentation of the matrimonial property regime, the law applicable to a matrimonial property regime should govern that regime as a whole, that is to say, all the property covered by that regime, irrespective of the nature of the assets and regardless of whether the assets are located in another member state or even in a third state. The law determined by this regulation should apply even if it is not a law of a member state. To facilitate spouses' management of their property, the regulation should authorize them to choose the law applicable to their matrimonial property regime, regardless of the nature or location of the property among the laws with which they have close links because of habitual residence or their nationality. This choice may be made at any moment, before the marriage, at the time of celebration of the marriage, or during the course of the marriage. I would like now to say a word about recognition and enforcement. Recognition and enforcement, in the light of its general objective of the proposal, is to give the possibility to give an answer to the judgments that were given in a member state. Therefore, the regulation should lay down rules relating to the recognition, enforceability and enforcement of decisions similar to those of other union instruments in the area of judicial cooperation in civil matters. The recognition and enforcement of a decision on matrimonial property regime under this regulation should not in any way imply the recognition of the marriage underlying the matrimonial property regime which gave rise to the decision. Now I would like to go to the registered partnerships proposal, and here again I would like to touch four aspects: scope, jurisdiction, applicable law, and issues relating to the recognition and enforcement. As to scope, again, here the UK and Ireland decided not to make the opt-in, and the regulation should not be applicable to Denmark. On the material scope, to provide unmarried couples with legal certainty as to their property and offer them a degree of predictability, all the rules applicable to the property consequences of registered partnerships should be covered in this single instrument. The regulation should cover matters arising from the property consequences of registered partnerships. Registered partnerships should be defined here solely for the purposes of this regulation. In fact, the actual substance of the concept should remain, and I stress, should remain defined in the national laws of the member states. Nothing in the regulation should oblige a member state whose law does not know the institution of registered partnership to provide for it in its national law. The second aspect that I would like to tackle is the issue of jurisdiction. The regulation should enable citizens to have the various related procedures handled by the courts of the same member state. To that end, the regulation should seek again to concentrate the jurisdiction on the property consequences of registered partnerships in the member state whose courts are called upon to handle the succession of a partner or the dissolution or annulment of the registered partnership. Where matters of the property consequences of registered partnerships are not linked to proceedings pending before the court of a member state on the succession of a partner, or on dissolution or annulment of the registered partnership, the regulation should provide for a scale of connecting factors for the purposes of determining jurisdiction, starting with the habitual residence of the partners at the time the court insists. Given that the institution of registered partnership is not provided for in all member states, as we know, the courts of a member state whose law does not provide for the institution of registered partnership is allowed to decline jurisdiction. In order to increase legal certainty, predictability and the autonomy of the parties, the regulation should enable, under certain circumstances, the parties to conclude a choice of court agreement in favour of the courts of the member state of the applicable law. The third aspect is the issues relating to applicable law. The regulation should enable partners to know in advance which law will apply to the property consequences of their registered partnership. The main rule should ensure that the property consequences of a registered partnership are governed by a predictable law with which it is closely connected. For reasons of legal certainty and in order to avoid fragmentation, the law applicable should govern the property consequences of the registered partnership as a whole, that is to say, again, all the property consequences covered by the registered partnership, irrespective of the nature of the assets, and especially regardless of whether the assets are located in that member state, in another member state, or in a third state. The law determined by this regulation should apply even if it is not the law of a member state. On recognition and enforcement. Recognition and enforcement, in the light of its general objective, which is the mutual recognition of decisions given in the member states in matters of the property consequences of registered partnerships, the regulation should lay down rules relating to this subject matter, similar to those of other Union instruments in the area of judicial cooperation in civil matters and comparable rules as with matrimonial matters. However, the recognition and enforcement of a decision on the property consequences of a registered partnership under this regulation should not in any way imply the recognition of the registered partnership which gave rise to the decision. Now that we went through the substance of the two instruments, perhaps I should say a word about the way forward on the future decisions on the proposals. Both texts reached a high degree of maturity. However, some member states have expressed the need for further reflection. Therefore, the Council, the Justice and Home Affairs Council in December 2014, was invited first to take note that the Presidency has submitted a possible compromise text on the two regulations. Secondly, to take note that a period of reflection was needed for several Member States in order to allow them to assess the results of the work completed so far. And thirdly and finally, to re-examine the possible compromise text on the two regulations as soon as possible, and no later than by the end of 2015, in order to assess whether the required unanimity can be achieved. Thank you.